Hello, I'm Attorney Dana, and I'm here to tell you a little bit about how you can take your idea and turn it into something that generates revenue for you. One of the things we're going to talk about in today's video is what a non-provisional patent application is. A non-provisional patent application is a very specific document that you file with the Patent Office. It has to have 5 parts. One part is the background of the invention. One part is the summary of the invention. One part is a description of the figures or the drawings, which means you have to have some figures and drawings that explain your invention. One part is the detailed description, and the final part is the claims. When you file a non-provisional patent application, the Patent Office does an initial examination of your patent application to determine whether all those components and all those parts are there. The other thing they look for is to see whether an inventor's oath and declaration is filed. Once the initial examination happens, the examining office sends you an official filing receipt telling you that all the things that they require are there, or they will tell you in that document if something is missing. Now remember, a non-provisional patent application actually gets examined. So it goes through this initial review process to see if everything is complete so that it can be passed on to patent examiners in order to have your patent application examined. Once you have the filing receipt, the official filing receipt, you can then expect a waiting period of about 12 months to 24 months before the Patent Office picks up the application and examines it. Okay, so now your application has been pending for 24 months. What can you expect? The Patent Office will pick up the application, review it, and an examiner will do a search to see if your invention has been disclosed in any reference out there in the world. Now, they're free to use any reference published anywhere in the world. It could be a published application, it could be an issued patent, it could be a journal that has technical information in it, it could be a newspaper article that's published. Anyway, they have access to various databases. They search those databases to see if they can find your invention in a specific disclosure somewhere out in the world, or if they can find multiple disclosures that together release or disclose your invention. So what happens is the examiner examines it, does a search, and then sends you what they call an official action. Typically you have 3 months to respond to that, and it is typical to have the official action reject your application and tell you that for various reasons they are not patentable. We have a whole nother video that explains all the different reasons that the examiners can use to reject your invention, and a whole process that happens around how we can help you with that. Anyway, now that your application has been examined and you've gotten a rejection, it is now time to respond to that rejection. What you do is you look at the rejection that the office gave you, and if you disagree with some points, you can write a response and file it in the application. And then the examiner looks at your response and then looks at what changes you may have made in your application, more specifically your claims, and based on that, will give you possibly a second action or a final action. All of these things are details that a patent attorney can help you with. This is not a process that you should be taking on by yourself, because there's many different rules and complexities to doing this. This is something that a patent attorney has experience in. This is something that we have experience in as patent attorneys and patent practitioners, and we can help you through this process. The other thing you need to know is when you file a non-provisional patent application, there is a filing fee. That filing fee with the government varies, depends on whether you're a large company that's 500 employees or more, or whether you're a small entity, or if you're a micro entity, which is based on your income. So typically micro entities are individuals that have an income level that falls below a standard level, which is identified in the statute, and it changes from time to time. The filing fee typically is around $830 for a small entity, and you double that for a large entity, or what they call the undiscounted fee. All that is what you need to pay to the Patent Office. Of course, there's a whole separate set of costs and expenses associated with having the patent attorney write up the patent application for you. And they can do that for you. And one of the things that we have another video on is how to determine what the cost is going to be and how much time the attorney will spend. So you can also check out that video. So now you have your patent application on file. It's a non-provisional. It's been examined, and through the examination process, that is something that can result in a patent. If the examiner decides that your claims are allowable, they will give you a notice of allowance, which then results in you having to pay an issue fee. That issue fee is either going to be $500 or $1,000 depending on whether you're a small entity or a large entity, and after that your patent will issue, and that's when your rights begin. So you don't really have any rights until your patent issues. You have a patent application that could be pending for about 2 to 3 years, and if the process goes as expected and you're successful, then you will have a patent that issues, and then you can exercise your rights. Remember, a patent application has 5 parts. It also has an oath and declaration that the inventors must file. That gets examined. The office will send you their examination report. And once you have their examination report, if everything goes well, you get a notice of allowance. That's exciting because now you're going to have a patent. You pay the issue fee and you're done. So all that added up, sometimes people ask, what does all that cost? Well, the only thing I can tell you for sure is what the government charges in fees, and we've told you that. So the filing fee for an application is about $830 if you're a small entity. You double that if you're a large entity, and then if you get your patent to be allowed, you have a issue fee that you have to pay, and that is currently at $500, but it changes from time to time. It can increase, but right now it's $500 for a small entity, and you double that for a large entity, and then you get your patent to issue. Until your patent issues, you really don't have any enforceable rights. You just have your idea pending before the U.S. Patent and Trademark Office. If you have any questions, feel free to give us a call. We'd be happy to help you. Number and link listed here.